Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss a very important case on section 153A assessment. The name of the case is Principal Commissioner of Income Tax versus MEHNDIPUR BALAJI. The case has been reported in 447 ITR at page number 517. The matter has been decided by Allahabad High Court and the date of the judgment is 4th July 2022. There is a lot of litigation on the point that whether assessment can be made in the such cases on the basis of the material which is on record. That is, whether the assessment can be made on the basis of other than incriminating material. On this point, there is a famous case of CIT versus Kabul Chawla, which has been decided by Delhi High Court, which says that the assessment cannot be made in section 153A assessment on the basis of other than incriminating material, meaning thereby that section 153A assessment is done only in the search cases. Search is made on the assessee when some conditions are satisfied, and you can go for the assessment only on the basis of the material which were taken by the department in the search, or you can say which was unearthed at the time of the search. But we have seen that when the assessments are being made by the assessing officers, they are not able to find the material in the search. So they try to make the assessment on the other issues which are not the subject matter of the search. So on this matter, there are a number of the judgments of the various tribunals and the high courts that the assessment cannot be made on the basis of the material which is other than incriminating material. But in this particular case, the Allahabad High Court has added more spice to the litigation and said that the assessment can be made on the basis of other incriminating material which is not the subject matter of the search. The court said that there is no mention in section 153A which says that the assessment cannot be made on the basis of other incriminating material. The court said that it will be out of the power of the court to interpret the section in a way that the assessment cannot be made on the basis of other incriminating material. The court said that there is no mandatory requirement that assessment under section 153A should be based on incriminating material during search. Or in other words, the court said that the language of section 153A is plain and unambiguous. The court further said that section 153A does not exclude assessment or reassessment on consideration of other incriminating material. So in this case, the court, by taking the example of in the positive way and the negative way also, made it very clear that the assessing officer is not bound by only the incriminating material. His area of scope is very wide. He can go deep into the books of accounts. He can go into the subject matter of any exemption which has been given to the assessee. So if the assessing officer wants to travel beyond the incriminating material, then it is in his power, according to Allahabad High Court, that he can make the assessment on the basis of both incriminating material found during the search and other incriminating material which is available on record. Friends, according to me, this case has laid down the foundation for the special leave petition which is being pending in the Supreme Court, and I think that this case has given a very big hint that what is going to be the Supreme Court judgment, because the courts are now very strict. We have seen that with due respect to the Honorable High Courts and the Supreme Courts, that the courts are very strict. Whenever they find that there is some laches on the part of the assessee for the tax evasion. And I think that it should be the mood of the country and it should be the mood of the courts also, that if assessee has done something wrong, then he should be penalized for that. Tax evasion is very bad for any country, especially for the developing countries where the government needs a lot of money for the development of the society. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal CIT versus MEHNDIPUR, Balaji. Thank you, friends.